Is that the bill be now read a second time. I call the member for Penrith.
Thank you, Speaker. I contribute to today's debate in support of the Health Practitioner Legislation Amendment Bill 2024. As highlighted in the second reading speech, the New South Wales Ministry of Health is currently in the early stages of a large-scale review of the complaints process under the Health Practitioner Regulation National Law, New South Wales. This review will ensure the complaints process under that legislation remains fit for purpose and meets the needs of the New South Wales community. However, key health stakeholders within New South Wales have identified options for non-contentious amendments, which should be addressed now rather than waiting until the review is finalised. The purpose of the Health Practitioner Legislation Amendment Bill 2024 is to make these non-contentious amendments to improve the complaints process under the Healthcare Complaints Act 1993 and the Health Practitioner Regulation National Law, New South Wales, whilst the broader review is ongoing. Schedule 1 of the bill introduces amendments to the Healthcare Complaints Act to improve processes for health practitioners, the Healthcare Complaints Commission and others involved in the healthcare complaints process. One way in which it does so is by introducing clarifying and consequential amendments. For example, the bill corrects an inconsistency in terminology under Section 14 of the Healthcare Complaints Act to ensure that health professional councils, such as the Medical Council of New South Wales, can take immediate action in relation to a health practitioner under Section 150 of the Health Practitioner National Law, irrespective of whether the investigation by the Healthcare Complaints Commission is ongoing. The bill also makes important substantive amendments to the Healthcare Complaints Act. These include allowing the Healthcare Complaints Commission to accept the oral withdrawal of complaints where appropriate, allowing expert reports obtained by the Commission to be used in proceedings under the Healthcare Complaints Act, and allowing the Commission to disclose information to overseas regulators where it is in the public interest to do so. Each of these amendments are directed to streamlining and improving how the Healthcare Complaints Commission deals with complaints under the Healthcare Complaints Act, with a view to protecting the safety of the public. The bill also makes some important amendments to the Health Practitioner Regulation National Law, New South Wales, to ensure the complaints process under the Act operates fairly, effectively and efficiently. For example, the bill makes necessary amendments to clarify the effect of a decision by the New South Wales Civil and Administrative Tribunal that if a person were still registered in a health profession, the tribunal would have suspended them. The bill provides that the person may not apply for registration during the period that they would have been suspended to ensure consistency with how suspensions for registered health practitioners operate. The bill also makes amendments to require health professional councils to provide written reasons when exercising their immediate action powers. Under the national law, health professional councils have the power to suspend or impose conditions on a registered health practitioner or student's registration if it is appropriate to do so for the protection of the health and safety of a person or persons, or if satisfied the action is otherwise in the public interest. These decisions can have serious repercussions for health practitioners and students. As such, the bill introduces a requirement for health professional councils to provide written reasons for these types of decisions and for the subsequent reviews of these decisions. Importantly, these reasons for decision are privileged and may not be admitted as evidence in civil or criminal proceedings, other than proceedings under the national law or in a coronial inquest or inquiry. The bill also makes changes to allow impaired registrants panels to reconsider their recommendations in certain circumstances. An impaired registrants panel is an independent panel tasked with inquiring into matters that may indicate a registered health practitioner or student has an impairment. Following conclusion of the inquiry, the panel may make recommendations that the practitioner engage in counselling, agree to conditions being placed on their registration, or that the practitioner be suspended from practising for a specified period. As mentioned in the second reading speech, once these recommendations are delivered in the report to the Health Professional Council, the Impaired Registrants Panel becomes functus officio and ceases to exist. This means that neither the council nor the practitioner can ask the same panel to reconsider any of its recommendations. Instead, a fresh impaired registrants panel must be constituted for this to happen, which can be a very time-consuming process. This bill inserts a new provision which allows an impaired registrants panel to continue exercising its functions after it has delivered its recommendations to a health professional council, and provides a process for the panel to reconsider its recommendations if appropriate to do so. The bill also introduces amendments to the circumstances in which performance assessors can obtain information. Currently, the national law only allows performance assessors to require answers to questions and records by physically attending premises where records are held or where persons are located. To avoid the need for performance assessors to attend physical premises when completing remote performance assessments, the bill will allow performance assessors to require information and answers to questions from individuals remotely. The bill also makes some updates to ensure proceedings before the New South Wales Civil and Administrative Tribunal and Professional Standards Committees operate as intended. This includes by allowing those disciplinary bodies to accept into evidence judgments and findings of New South Wales performance review panels and council inquiries when determining a complaint in relation to a registered health practitioner. Each of the amendments introduced by the bill is meaningful, appropriate, and necessary to ensure the Healthcare Complaints Act and Health Practitioner Regulation National Law, New South Wales, is fit for purpose and operates as intended. The bill improves the complaints process for key stakeholders impacted by these pieces of legislation, whilst ensuring the protection of the health and safety of members of the public. I commend the bill to the House.
The question